Hello, friends. Welcome to Laws and Scriptures 360. So, in today's video, we're going to talk about the legal battle between the ex-BB Niger housemate Fina and Alhaji Aliko Dangote. I know most of us are conversant with the facts of this case, and I mean, there was a time that it was all over the internet, all over blogs and all that. It appears I actually came late, but it's better late than never. Now, in today's video, we're going to be discussing um, the the legal principles involved in this case. We are also going to be discussing the likelihood of the ex-BB Niger housemate's finance claim against Alhaji Aliko Dangote. Please don't go away. If you've not subscribed to this channel, this is a very beautiful opportunity for you to subscribe and like and comment. And I assure you that you would enjoy every single time you spend with us in this channel. So we're going to start with giving a short recap as to the background story of what exactly happened that gave rise to the legal battle between Fina and Alhaji Aliko Dangote. Now, what happened is some 2 or 3 months back, um, Fina lost her younger sister as a result of the alleged reckless driving of one of Alhaji Aliko Dangote's staff, who was at the time driving one of his trucks while the deceased was on her way to school. Unfortunately, she was hit down by the truck of Alhaji Aliko Dangote as a result of the alleged reckless driving of one of his drivers. Now, she was immediately hospitalized. Unfortunately, she didn't make it out of the hospital. Now, Fina claims the sum of 1 billion naira from Alhaji for damages as a result of the death of her younger sister. Now, we're going to look at the legal principles in this case. We're going to look at the legal principles in this case. And one of the legal principles in this case that comes to mind is the principle of vicarious liability. Is the principle of vicarious liability. The principle of vicarious liability is the principle that makes an employer liable for the wrongful acts of his employee carried out in the course of his employment relationship. Now, this principle has about 3 or 4 ingredients, and these are the ingredients, these are the things that anyone claiming damages as a result of this principle must prove to be entitled to their claim. Now, one of the ingredients is that there must exist an employer-employee relationship between the person who carried out the wrongful acts and the person who is to be held liable for the wrongful acts of the other. There must exist an employer-employee relationship. Secondly, the that at the time the wrongful act was committed, he was carrying out his duties as specified in his employment relationship. The person who carry who the person who carried out the wrongful act was at the time carrying out or executing his duties as an employee of the employer. Thirdly, that there was actually a wrongful act committed. There was actually a wrongful act committed, and the wrongful act resulted in harm or damages. And the wrongful act resulted in harm or damages. You see that these are the ingredients, these are the things one needs to prove to be entitled to a claim under vicarious liability. Now, I'm sure at this time you would begin to analyze the case of the alleged case of the ex-BB Naija housemate and Alhaji Aliko Dangote. Sure, by now you will begin to look at it again. Now, there's a salient principle that will come to mind in this case. There's a salient principle that will come to mind in this case, and that is the principle of covering the veil. The principle of covering the veil of incorporation. Now, remember that Dangote Nigeria Limited is a company registered under the Corporate Companies and Allied Matters Act, rather, not Corporate Affairs, registered under the Company and Allied Matters Act. And by virtue of Section 42 of the Companies and Allied Matters Act, when an entity is duly registered, it becomes a body corporate distinct from its
officers like its directors and shareholders.
becomes a corporate entity that can sue and be sued, can own properties, can own shares, can do every other thing that an individual should do. Now, if I want to analyze this instant case, I would look at it from this perspective that that the employer in this instance isn't Alhaji Aliko Dangote. The employer in this instance is Dangote Nigeria Limited on Dangote Group of Companies. That is, this is the employer in this instance who should allegedly be vicariously liable for the acts of the driver who recklessly hit the younger sister of the ex-BB Naija housemate. Now, in order to, establish her claim, the first thing that she is meant to do is to sue the company as a body corporate, is to sue the company and probably, add Alhaji Aliko Dangote and the alleged reckless driver who carried out the wrongful act, as probably they will come in and testify as witnesses to establish a claim. But the person who is liable by law is the Dangote Group of Companies. Dangote Group of Companies is now a body corporate that owns its shares and can be liable because it can sue and be sued. So I'm sure Dangote Group of Companies already has its assets and has the wherewithal to establish or to pay for damages in any instance. Therefore, bringing Alhaji Aliko Dangote as the one liable in law may affect the merits of her case. It may even affect the jurisdiction of the court. So in the celebrated case of Nigerian Air Force and Kamaldeen, 2007 is a 2007 case, the court held the Nigerian Air Force liable for the act of an Air Force officer who assaulted the claimant in the course of his duties as an Air Force officer. So the court held the Nigerian Air Force liable, vicariously liable for his acts. Now, this principle of vicarious liability is not only limited to Nigeria, it is a principle that is universally applicable. So in the international case of Lister and Headley Hall, a warden who was employed rather to cater for children was caught abusing these children, and the House of Lords held his employers vicariously liable for the acts of the warden, because the damage or the act was actually done in the course of his employment. was done in the course of his employment. Now, I'm aware that at this point we will begin to give a second look to the legal tussle or to the alleged legal tussle between the ex-BB Niger housemate and Alhaji Aliko Dangote for employers to actually take precautionary steps in their course of employment, especially in terms of giving their employees the requisite training for the particular position they are to occupy to prevent issues like this, to also absorb them from being vicariously liable for any recklessness or unprofessional act of their employees. So it's actually my advice to employers, not just in Nigeria, all over the world, to take further steps in training and exposing their employees to the nature of the job that they are employed for, so that they will be adequately equipped to deliver on their job. I believe that you have learnt a lot today. I'm so sure that I've enlightened you today. And if you want to keep getting more of this, I'd like you to press or click on the notification button so that after you have subscribed and we post videos, you will be able to see them. You'll be the first to see them. Thank you very much for having me and enjoy the rest of your day.